Welcome to our deep dive on navigating layoffs while on H-1B status, and why an approved I-140 can be a powerful safety net. We will turn a stressful moment into a strategic plan, step by step. First, we will set the agenda and then move into the 60-day grace period, the power of I-140 approval, the B-2 change of status risks, and practical action steps. We will also include quizzes to reinforce key concepts. Let's begin. Here is our agenda. Why this topic matters. How the 60-day grace period works. Why an approved I-140 can act like a golden ticket. The risks of converting to B-2 status. The difference between change of status and consular processing. A practical action plan with a checklist, and short quizzes to reinforce learning. Now that the roadmap is clear, let's move to the core foundation, the 60-day grace period. Disclaimer. This content is educational and does not constitute legal advice. Immigration rules are complex and fact-specific. You should consult a qualified immigration attorney about your unique situation before taking any action. With that in mind, let's proceed to the 60-day grace period. When separation occurs, a 60-day grace period typically begins. It starts on the earlier of the last day of employment, or your I-94 or petition expiration, whichever is earlier. During this time, prioritize securing a new employer and filing a new H-1B petition. If you qualify, the filing can be cap-exempt. Alternatively, you could file a change of status to B-2 to extend lawful presence while you search. However, that terminates work authorization and can complicate returning to H-1B status. Next, let's unlock why an approved I-140 can transform your options. Quiz time. Question. When does the 60-day grace period begin? Options are A. The day a new job offer is received. B. The earlier of last employment day or status or petition expiration. C. The day the layoff email is sent. Or D. The day you file B-2 change of status. You may pause the video now to consider your answer. We will discuss the correct answer in the next section. The correct answer is B. The 60-day grace period begins on the earlier of your last day of employment or your status or petition expiration date. Correctly identifying that start date is essential for accurate planning. Now that timing is clear, let's focus on the advantage granted by an approved I-140. An approved I-140 fundamentally changes your position. It grants a permanent H-1B cap exemption, meaning you do not need to enter the lottery again for future H-1B petitions. This remains true even if your last H-1B validity has expired, or if you depart and later re-enter. New employers can file a new petition based on your I-140 approval. Consequently, you can prioritize finding the best employer fit rather than being constrained by the annual cap window. Next, we will examine why converting to B-2 is often a risky holding pattern rather than a clean solution. Filing a B-2 change of status can preserve lawful presence but terminates work authorization. If you later find a sponsor, requesting change of status from B-2 back to H-1B can draw significant scrutiny and is frequently challenging. A commonly safer path is consular processing. Depart, obtain H-1B approval and visa if needed, and re-enter to activate H-1B status. Now that we have the risks in view, let's contrast change of status and consular processing directly. Comparing change of status and consular processing. With change of status, you remain in the United States and may avoid travel logistics. However, when moving from B-2 back to H-1B, requests often face heightened scrutiny, increasing the risk of requests for evidence or denials, and creating timing uncertainty. With consular processing, you depart and re-enter with the H-1B approval, which can be a cleaner activation path after a B-2 period. But it requires scheduling, travel, and potential visa interviews. Next, let's map an action plan that prioritizes timing and cap-exempt filing where possible. Here is a practical plan. First, confirm your separation date, calculate the 60-day window, and gather documents. Next, immediately network and prioritize employers who can file a cap-exempt H-1B based on your approved I-140. Then, support your prospective employer through the LCA process and H-1B petition preparation, and consider premium processing to reduce uncertainty. If timing becomes tight, file B-2 before day 60 to preserve presence, while discussing with counsel whether consular processing or change of status best fits your facts. Finally, Ensure the H-1B petition is filed within the window, or plan consular processing and re-entry to activate status. To visualize this timing, let's look at a timeline diagram. This timeline shows the layoff at day 0, followed by document gathering and attorney consultation in the first week. From roughly days 8 to 30, focus on interviews, securing offers, and the labor condition application. Between days 31 and 45, finalize petition preparation and decide on premium processing to accelerate adjudication. From days 46 to 60, either file the H-1B petition or, if necessary, file a B-2 as a fallback to maintain presence, while planning for consular processing if change of status is inadvisable. Now let's reinforce the I-140 advantage with a quick quiz. Second quiz. Question. With an approved I-140, do you need the H-1B lottery for future H-1B filings? Options are A. Yes every year, B. Only if you left the United States, C. No, you are cap-exempt indefinitely, or D. Only if your I-797 expired. You may pause the video now to consider. We will give the answer next. The correct answer is C. With an approved I-140, you are cap-exempt indefinitely. You do not need to go through the lottery again for future H-1B filings, even if you previously fell out of status or departed and returned. Next, let's lock in the key takeaways and a practical checklist. This checklist highlights documents to assemble: your I-140 approval notice to establish cap exemption, your most recent H-1B I-797 approvals for history, recent pay stubs and prior offer letters for verification, your I-94 and passport for identity and entry records, an updated resume and reference letters to expedite hiring, employer-side labor condition application postings for compliance, and any B-2 filing receipt if you use that strategy to maintain presence. Now let's summarize the main ideas before we wrap up. The main takeaways are: first, the 60-day grace period should be used to find a new employer and file, not just to file B-2. Second, an approved I-140 confers permanent cap exemption, eliminating the lottery from your future H-1B filings. Third, while B-2 can preserve presence, it complicates change of status back to H-1B and may make consular processing the cleaner path. Lastly, speed matters. Align quickly with an employer and time your filings carefully. To close, here is a concise markdown summary you can screenshot. Here is a concise markdown recap. First, use your 60-day grace period to secure and file a cap-exempt H-1B if you hold an approved I-140. Second, avoid defaulting to B-2 unless necessary, because it terminates work authorization and complicates a change of status back to H-1B. Third, if you do use B-2, plan for consular processing as a safer reactivation path. Fourth, maintain a ready document set to support rapid filings. Finally, let's summarize and wrap up with next steps. Before we close, remember that with an approved I-140, you likely have more control than you realize. Manage your timeline carefully, prioritize employer alignment, and file decisively. When your facts are complex or timing is tight, consult an experienced immigration attorney. To end on a high note, let's thank you and invite you to engage with the channel. Thank you for watching. If this video helped, please like, share, and subscribe. Share your biggest questions in the comments so we can cover them in future episodes.